You've got a limp, you've got back pain from the nerve impingement again. They got the claws.
Ladies and gentlemen, welcome to this special edition of the Justice Team podcast recording live from San Diego. We have some ambient trains behind us. We have the Petco it's to the right behind us.
That's it. Yeah.
So you can hear some baseball. What's not on right now? Yesterday was a day game. We heard a grand slam in one of these during the time.
I was there.
You were there?
That was great.
That's the voice of the sultry and famous Rob Cartwright. Rob, why don't you say hello? You're our special guest today.
Hi there. Great to be here.
Nice.
And I was pleased to see the Giants win yesterday.
Oh, and as you can tell, he's a Bay Area trial lawyer, Rob Cartwright. We also have Sienna Coyota-Bote. Sienna, what's up?
I was going to say, is it welcome? Is that how you say welcome in Iceland?
Sort of.
How do you pronounce it?
No, people don't really say that.
Oh, I saw it on your website.
We say bless.
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 Nice. I like that.
Oh, nice.
So, Rob, what's your tie to Iceland? I mean, we're going to start with some cool, because if anybody don't know Rob Cartwright, he's one of the coolest lawyers, human beings ever, with some cool backstories. Good.
Well, the tie to Iceland is my mother's of Icelandic descent, and so she actually wanted to be representing Iceland in the Bay Area, and through her efforts, I met the ambassador back in the early 90s, and ultimately he appointed me as consul and then consul general in 1996, which I've served continuously since then.
So that Icelandic tie, is that tie to Valhalla? Is that why you're such a daredevil with an iron liver? Is that how you get it, man?
Well, yeah, the Vikings are rather notorious for those kinds of activities.
What's your most famous like pillage raid? I mean,
Mine personally?
Yeah.
Well, we'll just keep that confidential.
Nice. So, if you don't know Rob, he's also race car driver, marathon runner.
Former marathon runner.
Come on. What was it?
Before I broke my back skiing. Yeah.
Before he broke his back skiing.
Yeah.
So, I mean, tell us about that. Like, what drives you to get into that stuff? And what kind of cars are you racing, you know?
Well, I was really active in racing some years back. I started because George Chulos was racing. He's a good friend of mine. And he had crashed his car and couldn't afford to buy a roller. They call it a roller when it doesn't have a motor. So his motor he thought was still good. So I loaned him the money for the roller. He put the motor in it, and of course it blew on the very first race because the motor was damaged from the crash.
It reminds me whenever Evan tried to race Tom Conroy in our office, and his hamstring blew after.
It blew out. I had him 2 steps. I could see the finish line, and boom.
He's the second fastest in the firm.
I suddenly became the owner of a race car with no motor.
That's like a trial lawyer without a voice.
Yeah, so that's how I got into it.
Man, so I mean, you ever crash one?
Yeah, I've crashed at very high speed, done end over end flips and barrel rolls and that kind of stuff. It's one of those sports where you're going to crash.
Well, I'll bet you in that crash you had no mechanism for injury because there's no way to even herniate a disc in a car crash. I mean, these biomechanical experts told us this all the time in trial, right?
Just a pillow fight, I believe, actually.
You could probably just herniate with sneezing.
Yeah.
Well, if they made street cars as good as they make race cars, there would be a lot fewer injuries, I can tell you that.
Wow.
So, Rob, you're the current president of SFTLA?
That's right.
So tell our listeners what that acronym stands for and what you do.
San Francisco Trial Lawyers Association is our local trial bar, and we put on all kinds of educational programs throughout the year, number of great social events. We have a dinner that honors the bench coming up in September, and then we have a Trial Lawyer of the Year dinner where we select a trial lawyer winner each year.
Very cool. And are you the founder of Western Trial Lawyer Association?
No, my father was one of the early presidents, but I've been involved for many decades, and I currently helping to run the education program. So it's.
Yeah, we just had somebody stop by the booth. He practices in Idaho, and I told him about the Western Trial Lawyer Association. It blew his mind. He's like, "Well, I can go hang out with my friends, get educated, ski at some of the most fabulous resorts in the world,
Sure,
and go to Hawaii."
You bet.
So tell our listeners how can you get involved, and what kind of stuff do you have upcoming for Western trial lawyers?
Well, it's a great group because we really do select really top-notch speakers to come. People that have achieved just tremendous success in the courtroom and that have great reputations. And most of the attendees are also fairly accomplished. And so it's a great alternative to, say, California trial lawyers or AAJ, where we come here and we are politically active and there's a lot of committees and so forth. Western is just more relaxing. We go and we enjoy each other and we share with each other and network with each other, and usually in a beautiful place, and we have a good time together.
That's right.
It kind of helps recharge your batteries.
And it's a lot of it's those late nights together till 2, 3 a.m. enjoying those fine spirits that really bring us together, isn't it right?
Well, Hawaii's not such a late night place.
Nah.
So
Sun goes down, we go to sleep there.
Yeah.
Right? So what are your dad was a lawyer?
My dad was a lawyer. He was one of the early presidents of ATLA, and he was the first inductee into the AAJ Hall of Fame. His name's up on the wall here.
So, you're
Bred for
famous.
this, yeah.
This
It's in your genes.
Yeah,
Right,
literally
definitely.
it's in your genes.
Well, I grew up with a lot of stories about various cases around the dinner table. So
Yeah, so let me ask you what that's like. I mean, I'm the son of a truck driver. I just get told really funny stories about things that go on during driving a truck. But what's it like to be the son of a trial lawyer, and how is it that you took on the same passion that your dad did?
Well, it's an interesting story. I always told my dad I'd never be a lawyer because I saw how hard he worked, and a lot of late nights and weekends. And I said, man, that's just not for me. But growing up around a trial lawyer, you just kind of pick up a proclivity to want to help people to get involved in these fights and these interesting cases and do a great job. And as I got older and started working in the practice and working on some cases with my dad and going to trial with him, I fell in love with the whole thing and decided that I wanted to do this as my life's work. And as I've gotten older and I do less race car driving and motorcycling, I actually just love it more and more the longer I do it, and it becomes increasingly
you're
more
on
fulfilling.
a lot of leadership roles, president of organizations, always there to support the fight. So I have to ask you this: how is it you're able to maintain your practice while giving back to consumers overall by all the work that you do?
Well, I think growing up around my father, lawyers that represented plaintiffs didn't have the tools that we have now. They didn't have the laws that we have now. And it was the generation before us that did donate their time and their energy and their money to getting their cases through the courts and getting them affirmed on appeal, and moving legislation that now gives us the rights that we can enforce on behalf of our clients. And I think it's incumbent upon every trial lawyer to not just take from the system, but to give something back. And I really think it's part of our job in representing our clients and getting justice for those that we represent in the broader sense.
So what are the, for you right now, 2019, almost 2020, we're 6 months away or less, what are some things you see on the horizon or things that interest you now?
Well, as I've gotten older...
Besides race cars and breaking your back skiing and that kind of stuff.
Well, really, I've grown my practice. I have 4 offices in Northern California.
King of the North.
And I have cases pending everywhere. And as I've gotten older, I'm just less interested in, all the other things that I did when I was younger. And so my practice has really become my passion, and I just am enjoying it more than ever. And so what's on the horizon are a lot of very interesting cases.
Nice.
And challenging cases. We've just finished a very challenging third-party, basically a shooting case, which was
shooting case.
Very challenging. We've had several, and this one was interesting. It was tough.
So you're not going after the actual shooter. I assume the shooter has
Well, we sued the shooter, but we're not going to collect anything.
No.
So we went after the facility where party took place. It was a rave on Halloween called Blood Halloween, and we sued the security company, we sued the promoter, we sued the producer.
Wow.
And ultimately, we've settled the case for some significant money.
I mean, and what are some of the things that you found that was able to hold people like that accountable?
Well, these are difficult cases. There are a number of legislative, well, I wouldn't even call them that. The city council has established certain guidelines about event promoters and nightclubs. In San Francisco, we've had a lot more nightclubs come in the last 10 years, last 20 years than there used to be. And as a result, there's been a lot more violence and a number of shootings. And certain club owners have been involved in particular with some of those nightclubs. And so they've established some rules that would require security, certain minimum levels of security, as well as a zone of danger that extends 1,000 feet from any particular nightclub. And while this was not a nightclub shooting, it was kind of analogous to one, so we used that as kind of a standard of care.
Wow. I mean, that's a challenging case.
Yeah, our client was shot about a third of a mile away from the facility, so it made it even a little more challenging. Yeah.
So where did you come up, or where did you find that the 1,000 feet zone of danger?
It was in the public record at a hearing, and interestingly, one of the people involved in the event, who owns another nightclub, had actually been at that hearing, and we have him on tape talking about the appropriateness of that sort of a guideline and security levels.
So tell me he's an advocate for it.
Actually, he sort of was.
Okay.
And the main promoter actually had one of his clubs shut down because there'd been so much violence.
So do you have, with your active rock star lifestyle, does it ever pair well with doing certain types of cases? Like, do you find product cases more interesting or easier because you work with race cars or mechanical knowledge?
I think racing has really helped me in a number of ways. Number one, understanding vehicle dynamics when you've been
Do you have a need for speed?
I apparently do.
Do you like Speed 1 or Speed 2 cruise control more? Evan, what's your favorite?
I like pedal to the metal.
Yeah, I mean, you gotta go number one.
Number one
Sandra's
classic.
a nice little favorite of mine.
Yeah, me
as well.
too.
Wow.
Keanu Reeves.
My
Wasn't she in the second one, though?
I don't remember.
With Jason Patrick, right?
I don't know.
Some of my neighbors
I
have
go classic.
nicknamed me Full Throttle.
Full Throttle. I like that.
That's pretty sweet. I'm gonna steal that.
They nickname Evan Full Bottle.
Yeah, that's half true.
That's after he always
like-
has half
you
a
like
bottle. He never finishes them.
Yeah.
Nope. But I will tell you, and kind of bringing it back to the whole Iceland situation here, one of my favorite beers of all time is an Icelandic pale ale. It's fantastic.
Really?
Yeah.
Well,
It's
Iceland-
perfectly hoppy.
They have not been in the beer business very long, so I'm glad to hear you like it.
Yeah, it's I guess some guy in the Pacific Palisades. He has ties back there, and he brought it back. Cool.
Didn't Bob save Morrill from dying?
Yeah, one of my friends, we were hiking a lava tube in Iceland, and our guide wanted to take our photo, so we took her helmet cams off, like the miner hat look, and it was complete pitch blackness. He was going to take a photo, and I just heard the ground crumbling next to me, and I just reached down and grabbed my buddy's like back of his pant butt, like Mauro. You Mauro Fiore, big guy. Do you know Mauro Fiore?
He's a-
Do you
I
know
don't.
Mauro? Big guy. So he's hilarious. But anyway, he was falling down, and I just happened to save. But the tour guide took a photo, and it's really funny. This guy's falling. I had my hand in his butt. It was pretty.
You saved him.
Saved him.
He's a hero.
Yeah. Oh man, or a zero, one of the two things. But Iceland was awesome. I mean, so much cool stuff to do.
People have no idea how beautiful it is till they
my
get there.
God, yeah.
It's just really spectacular.
Yeah, we had a really good time. I actually found bought it at, I don't know where I got it, but have you ever had a Viking honey wine?
I may have. I've had several different sort of sweet wines from Iceland.
I mean, it was and I picked it up at the grocery store. It's called a Viking Blood. I was like, this sounds interesting. It was 20% of alcohol, and it was a
Wow.
honey
Wow.
wine. I've never
That's,
tasted anything like that.
Well, the Icelanders like
potent.
they like their drinks.
Impotent.
Yeah.
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 They also like their music too.
Yeah, they have just some terrific music, some great talent there, and a lot of it's very avant-garde, very different.
So growing up in your household, do you remember any specific cases or issues that your dad worked on that like inspired you, or
Well, yeah, so many.
or scared the crap out of you? One of the two.
Really, a number of cases. I remember one of my high school buddies invited me to go to Russian River, and he went up. I couldn't go that day, but a number of them went up, and they were drinking beers, and they were diving into Russian River, and one of them hit a rock and became a quadriplegic, and that was a very difficult case. We sued the campground owner, and my friend who just passed away from cancer this last January, he at that time was given about a 10-year life expectancy.
Wow.
But my dad had to try that case, and I sat through parts of that trial. It was before I was a lawyer, and I was very inspired to watch him win that case. It was the largest verdict in the county at that time. And then when I was just becoming a lawyer, I got to sit in a trial down in Los Angeles. It was basically a business tort case where he got a $10.5 million verdict on essentially a zero offer kind of case.
10.5, and when was that verdict about? What year?
Well, it had to have been about 1982.
Wow.
81, I guess, actually.
I mean, with inflation, that's got to be what, like 50?
At the time, it was like huge.
That's insane. It's huge now.
Yeah.
Jeez.
Right.
Yeah.
So it was those things were really inspiring. But he was involved in a number of appellate decisions in California that moved the law forward. I mean, there's over 100 that you can see if you look it up his name. But that really did change the law, comparative fault laws, and just a whole bunch of things.
So what work is kind of your passion on the side? If you had to pick a practice area.
Well, I really like product cases,
Yeah.
and I used to do a lot of them. I think before the days of the internet, when I was trying these cases, you would have an injury come into your office, and you couldn't figure out that there were other people injured because the manufacturer would deny it, and you couldn't just go online and find people. So you're often trying just a one-off case. And that we now are all mass torts, you know.
Right. So if you some practice pointers for our listeners on a product case, what are some nuance or things you can do to help win your case?
Well, I think, you know, the theme of profits before safety is always a good theme in a products case. And I think learning all you can about the product, I think it helps, like for me, having some mechanical ability, having worked on the race cars and so forth. But really getting into the nitty-gritty of what failed, why it failed. And although you aren't necessarily required to have a reasonable design alternative, it's good if you can come up with one, because you often can, and it's just.
And how do you go about doing that? Because I have a product case coming up in October in Long Cause in LA, and we did this. We actually had an alternative design created for a foot guard on an ATV, but there's also so when you're trying that case, do you use the alternative design theory? Do you use consumer expectations? Like, what do you find to be the most bang for your buck, the best way to do it?
Well, I think you got to start with what happened. You know, what failed, or how did the injury occur? Was it through a use or a reasonable misuse, for a foreseeable misuse? And then you need to say, well, how could I have prevented this or stopped it? So if you start from there and consult with your experts and basically just sort of brainstorm on it and start looking at ideas and alternatives, it's surprising how often you can come up with something as far as a design.
So when you say you get into the nitty-gritty when you're learning the science, learning the product, how do you do the same when you're trying the case when you're with the jury? You're still getting into the nuances, very specific details to
Or
everything?
how do you break it down for them?
I think not necessarily. I think once you get into trial, it's KISS.
Yeah.
It's keep it simple, stupid, and really try to streamline your case, simplify it, condense it, and just get it out there.
Yeah, because I've heard, I'm a big believer of
just
efficiency.
make it like an obvious thing, like a duh sort
and
of thing.
Try it quickly, efficiently, and don't get into lost in the science with it. And I've heard some other people say, no, you want to take the jury through everything, make it feel important, go through every issue, have your experts on the stand for multiple days. I'm not that thought. That's not how I try cases. So it's interesting to know how you prefer to try a products case and what do you think is successful.
Well, I think if you can simplify the case and get to the point where it just seems so obvious that something is wrong, that it was so simple to fix it, and it would have been so inexpensive, and they just didn't do it because they didn't care, or maybe they were saving $2 a unit times millions of units, or whatever that is. I think what you want to do is build momentum in the case so the jury becomes angry at the decisions made by the manufacturer. And if you can do that, you will more often than not get them to punitive damages, which is ultimately where you need to get.
Yeah, and have you ever gotten, and there's very few trial lawyers that actually get to that step, that get to the check the box to get to the next phase for punitives? Have you ever gotten there?
Well, one of my early cases was a saw, a Sears and Roebuck radial arm saw. This was, again, back in the 80s, before the internet, and they denied other injuries and denied other lawsuits. And literally from going to courthouse and pulling filings, we found...
That's what you did to
we
find
found
other
about
similar
over
incidences.
200 other cases
Wow.
filed. I tried it against a lawyer that had tried 20 times or something, the same case, and they'd never lost one. And so they offered me zero, of course. And
They weren't ready for full throttle.
so I came up with some alternative designs, and they denied that any guard would have prevented the amputation anyway. It was a hand injury. So I made a hand out of chicken parts in like a rubber glove and ran it through the saw with various guards and without the guard, and splattered chicken guts all over the conference room. But I videotaped it and I showed it to the jury, and they were convinced that had there been a lower blade guard, my client would not have had the amputation.
Wow.
So they awarded, I can't recall exactly, but I think it was around $1.2 million for the hand amputation. He had his hand successfully reattached. But then they came up with about another $4 million in punitive damages.
Nice.
And
You actually got that
and
box
so
check.
and then that went up on appeal twice. It ended up being a 10-year ordeal. But after we won on appeal, the Consumer Product Safety Commission caught wind of it and recalled 3 million saws.
Wow, so you actually saved a lot
as a
more other
result.
people.
I think we prevented many injuries there. Yeah.
Wow. I mean,
that feels
anybody
good.
that doesn't do, for listeners that don't do product cases, they are time consuming, they are expensive, and they can last multiple years because they got unlimited funds, man. They're going to appeal.
These are very well-heeled defendants.
Well heeled. I like that term. Do you ever fear for your life? I mean, do you ever think? Honestly, I have that. You know, when you're going up against the big dogs and you're kicking them in the mouth and taking money out of their pockets. Like, do you ever have that worry?
I know that my father did a few times, and I know there was some surveillance and some trials that
Really?
so forth. Yeah,
That's crazy.
I just don't really worry about that, but I have sued some fairly dangerous characters that made me nervous.
Man, dude, that's fascinating stuff. Well, you know, Rob, I want to thank you for coming on today. If any of our members want to find you to talk more about your race car driving or product cases or just how they can help trial lawyer communities in a consumer fight, what's the best way to get a hold of you?
It's really easy. Just go to cartwrightlaw.com. All my contact information's there. It's cartwrightlaw.com. And happy to talk to any of your listeners.
Perfect. And I ask this of all of our trial lawyers that come on the podcast, so we're going to end with this. Do you have any weird superstitions that when you're trying a case you stick with, or some quirky things that you do?
I do.
Nice. Everybody always does.
Come
on, let's go.
Some won't share,
But I keep them private.
No. I knew it.
Oh, I
They're-
love it.
They're weird little OCD things. You know.
Everybody has them. I even down
Just
to
give
the
us one.
shampoo
Just
I'm
give us one.
using, or I mean, I'm trying to think of some of the weirdest ones that people had. A couple of people had the same one, is they always give money to the homeless as they walk to the courthouse. These types of things. I think that's a little less superstition, more. You know.
I do that like in the week or two following, preceding a trial,
Yeah, it's
and
like
during the trial.
It's like a karma thing, right? I mean, anyone that you could share with us, any little OCD thing that, I mean, we all have them. Look,
Same thing for
I
lunch.
have just
I don't pick up
I've
money
got all
unless their
kinds of
head's
weird
up.
little twitches and quirks and all kinds of stuff that I do, with my face. And try to not have the jury see me, but yeah.
So you have an amazing voice that carries, and it sounds so good on radio. Do you do any other type of commentating or radio shows?
No, I don't.
Wow, you should. We've got to get Rob Cartwright on more often.
I did want to add one point about that you were talking about earlier about participating in these groups, and so I was president of the California Trial Lawyers in 2002, and just to give you an example of why it's important, that was the year that I worked really hard for actually a couple of years preceding that to get legislation passed, and we got the 1 year statute of limitations extended to 2 years, and there used to be summary judgments filed in every case, and you had 28 days to oppose them, and now we have 75 days. We got that rule passed, and I just think it's been very helpful to every practitioner, and that's why I think people have to jump in and participate and be part of the program.
And we don't realize there's a lot of bills that have to be killed that come to the other side.
We kill thousands of them.
Yeah, and then ones because we're always battling $1 to 10 on every issue.
Yeah.
We were shooting here live. We saw our lobbying wing, Leanne Trenton, walk by, and she does.
Nancy Drabble.
Yeah, Nancy, they do a good fight for us out there.
Yeah, they're terrific.
Yeah. Well, thanks for coming on, Rob. Check out his website, and just a great guy. If you see out, have a drink with, one of the best human beings with the coolest war stories. Maybe after a few, we'll get to hear some of those OCD quirks, or maybe we'll see.
I want to hear about yours.
Man, I got way too many, man. I used to play baseball. That's all you got to know about that. So, ladies and gentlemen, thanks for tuning in. Media@justicesteam.com for any questions. And remember, Evan, what do you have to tell our listeners?
No sleep till justice.
Yes.
Thanks for having me.
Welcome to another episode of the Justice Team Podcast. We have a very special guest with us. He just walked in right off the street.
Right off the street.
He is famed appellate attorney Jeff Ehrlich. Say hello, Jeff.
Hi, and honorary member of the Justice Team.
Yeah, you've done
Absolutely.
You've done some very, very important cases with us on appeal. Probably the most important one, which we'll get to in a second, but we'll say hi to the rest of our panel. Tom, the lesser Tom Conroy, not Tom Fair.
Not Tom Fair, Tom Conroy. Once again, fulfilling the federal mandate that there be at least one Tom on the podcast at all times, so we are in compliance with all relevant ordinances.
And our resident trial attorney, Sienna Collado Bote.
Good afternoon.
So, Jeff, you, I think you're most well known for your appellate work, obviously.
Most likely, yeah.
I want to, and you and I have presented on this in the past. You are at the forefront of probably the biggest issue in personal injury, which is medical billing, medical liens, medical insurance. What's the current status of the law in terms of collateral source role? How do you elicit medical bills, testimony, lay the proper foundation? Give us the crash course.
Well, that's a mouthful.
A loaded question.
Yeah, I'd say the issue that I dealt with for you guys in the Pebley case was in the trial there. The defense position was because our client, Mr. Pebley, had access to health insurance. He was a Kaiser member, and then he became Medicare eligible for his treatment, but he chose not to get his care through Kaiser or through Medicare. He treated with a surgeon who he paid cash for, and the surgeon took a lien. And so the defense position was that Mr. Pebley's medical bill should be capped by what Kaiser would have paid. And their theory for this was mitigation of damages, that if he had the ability to get his care less expensively, he had an obligation to the defendant, in essence, to do that.
And Tom was a former defense attorney. So Tom, why don't you give us your perspective from a defense perspective, of what their argument was? He said mitigation of damages. Why should they be capped at what insurance paid? From a defense attorney standpoint, what would have been your argument?
Well, as a former defense lawyer, I think I probably used it in actuality, was if somebody's got insurance, paying into an insurance plan, has insurance, and they have a duty, as every plaintiff does, to mitigate their damages, rather than go get some expensive treatment somewhere out of plan or with a doctor on lien, they should use their insurance or work within their plan, which in theory at least would keep the medical bills down.
And Jeff, how did that play out?
In the trial, it didn't play out too well. The trial judge, it was a wonderful colloquy in the motion in limine hearing, and the trial judge listened to that very argument and said, So by that logic, shouldn't the plaintiff be obligated to go down to Tijuana or to Cuba to get medical care as cheaply as possible?
And I've heard that argument in trial that attorneys have been allowed to do that.
You can go on YouTube and learn how to do surgery on yourself.
So,
yeah, if you really want to mitigate damage, just do it for free.
So the trial judge said, asked this question, and the defense lawyer hadn't thought it through completely. Yeah. And you could sort of see that even on a transcript, sort of a deer in the headlights, like, I've sort of stepped into a bad place. Yeah. And said, well, that's an extreme case. Sort of not realizing that, no, that's just where your argument leads. So the judge wasn't impressed. The judge denied it. You guys got to try the case. It was a normal case. You got a great result for Mr. Pebley. And then on appeal, the defense decided that this would be the test case for this issue. And so they got a really good appellate firm, Horvitz and Levy, and they made the best case. And we ultimately prevailed. And the Court of Appeal in Pebley, the 2nd District Division 6, wrote and said it's really not for the defendant to dictate who provides the medical care for the plaintiffs that they injure. That choice belongs to the plaintiff. And it makes sense. I pointed out to the court that the defense argument is sort of premised on this idea that plaintiffs will want to inflate their medical bills to somehow make a better case. And I pointed out that it's probably more reasonable to think that since the plaintiff is the one that has to bear the ultimate risk of a bad outcome, that really what plaintiffs probably have the most incentive to do is try to get the best medical care that they can swing, regardless of how they do it. Because if it goes bad for them, they live with that for the rest of their lives. So in Pebley, it's a spinal fusion surgery. If that went bad, really bad, not only could he have died on the table, but he could have been paralyzed, lost the use of his hands, etc. So it wasn't likely that he was just fishing around hoping to run up the bills.
And Sienna, you've tried cases before and after the Pebley era. We call it the Pebley era. Thanks to Jeff, we have now an ironclad law of no evidence of health insurance rates in the courtroom if the patient treated on a lien.
Jeff is the meteor that wiped out the dinosaurs.
Yeah. Can you tell us, what a difference that ruling and what specifically Jeff? I mean, he's being a little modest, but if you read the Pebley ruling, and a lot of appellate rulings are really, kind of a pain in the ass to read, and they're long, and it's very long-winded. This is I encourage everybody listening to actually read that decision because it's important, A, but B, it's very well written and very easy to understand, and they actually took a lot of what was in Jeff's briefs and threw it right into the ruling.
That was very gratifying.
Yeah. And so, Sienna, you tell us, what a difference that ruling made in the actual courtroom, because you see it actually play out in the trial phase.
I hesitate because most of the cases I've done post-Pebley have been the judge follows the law.
Yeah.
But most recently, without naming any names, this judge started motions eliminate like 5 minutes in saying he's not a fan of Pebley and created his own ridiculous standard as to how to prove medical bills and told me I was not going to be able to prove the medical bills no matter what I did. And I did so with a unicorn doctor in a sense. I'm like, I'm going to bring in my medical bills. But I think some people are struggling with that decision still. And but on the cases where the judge follows the law, it's been so much easier to prove our past medical expenses.
Can a judge say I'm not a fan of the law and just?
Yes, it's a code.
Yeah.
I'll pass it around if you guys.
I'm not really a fan of this state's drug laws, so I'm going to go ahead and do what I want.
It's an interesting, approach, and what I had said earlier that the defense bar wanted to make Pebley a test case. So when they petitioned for review or depublication, and there were at least 23 separate submissions from insurance companies, defense lawyers, law professors, all trying to convince the Supreme Court that Pebley was a problem and that it should either, if it wasn't going to review the issue, should just certainly depublish it. And the court let it stand. And what's significant about that, and people don't understand, is that Pebley's the only published decision in the state on this issue. And as a result, under auto equity sales, it binds every trial judge. So whether they're fans or not, it's binding.
So what if, and I've heard this, when Pebley first came out, they said it conflicts with Howell. So there's a split of opinion If you don't know what Howell is, Howell says if you treat on insurance and insurance pays a certain amount and adjusts or writes the rest off, you can only recover what was paid by insurance. So when they say, well, there's a split in authority because they're two different districts, the Howell court actually conflicts with Pedley. What's your response to that?
Well, it's ridiculous.
I'm not a fan of that theory.
I mean, if it conflicted with Howell, the Supreme Court would have depublished it because
Right.
Howell's a Supreme Court decision. And that argument was made over and over again. That was one of the bases they sought review for, and the defense kept saying it's inconsistent. So if you want, I can explain the theory and what's wrong with it.
Sure.
That'd be
All
great.
right. Okay. So the theory
We're
is-
students, man. We could
right.
listen to you.
So Howell essentially decided one issue, and it's not a hard issue to spot what the holding is, because twice in the Howell opinion, the Supreme Court says, we hold, and then there's a colon, and then there's a paragraph that explains what the holding is. So the holding in Howell was fairly tightly focused, and it is that when a plaintiff treats through insurance and the plaintiff's medical providers have pre-existing contracts with the insurance company to accept a certain amount as payment, then that's the only obligation that the plaintiff has incurred, is to pay those providers what they've agreed to accept. And so if they're paid in full, it doesn't matter if before they get paid, they send out some crazy bill that says, you owe me $25,000 when they've agreed to accept $1,400 as payment in full. And so in how the plaintiff's bar's argument was that the differential between what the plaintiff providers had agreed to accept and what they billed was called the negotiated rate differential, that was actually an insurance benefit and belonged to the plaintiff under the collateral source rule. And Howell said, no, it's not a benefit, and it doesn't belong to the plaintiff, and you never incurred it. And so that was the end of that. So after Howell, a case called Korenbaum was decided, which had the same facts as Howell, in that the plaintiff was treated by insurance. There was a negotiated rate differential. And then the Korenbaum court said, well,
Korenbaum was my case, by the way.
okay.
Oh, was? That's why you nudged me?
All right. Korenbaum said, we're not going to allow these medical bills, which are for more than the treaters have agreed to accept. They have no evidentiary value. And that Howell also said that because those bills have no evidentiary value because they don't represent any obligation that the plaintiff has incurred, they're not admissible to show past.
This is
medical
only in the context of insurance actually paid for a portion
right,
of the bill, right?
Right. So then I'll stop while the plane.
We just had a flyover for the Padres game. You might be able to hear it on our broadcast. Some fighter jets just flew over. Pretty cool.
At least that's what we hope is happening.
Yeah, I hope it was just a.
That's for us, dude.
So then Korenbaum extended Pebbly and said that basically medical bills that have not been paid are simply inadmissible for any purpose. Then there was a follow-up case called Dorado, which is actually Ochoa versus Dorado. It was one of my cases. And in that case, the trial court had allowed the medical bills to come into evidence because the plaintiff had treated on a lien, but he wouldn't allow the treating doctor to testify that the bills were reasonable because the plaintiff had not designated the treating doctor as a retained expert. So there was no testimony allowed about what was reasonable. And the Court of Appeal reversed and said, no, you can allow the treating doctor, if you lay a foundation that they understand how medical billing works in their community, to testify about what's reasonable. But the bills themselves can't come in. So you have to understand that this particular court that decided Korenbaum and decided Ochoa, the late Justice Krosky, who was a friend of mine. I got to work with him. He's a phenomenal justice. But he liked to do things a certain way, and he had a conception that the evidence of what the medical bills were or the charges were could come in from the treating doctor or from expert. But the physical manifestation of the bills, the actual physical bills, couldn't come in. Other courts have not seen it that way. So you've got the Bermudas, another justice team case, that says we don't agree with that. You've got courts at Moore versus Mercer up in Sacramento. So in most cases, the bills can come in. But the defense position is that if you look at Korenbaum and Pebley and cases that have followed Korenbaum, they don't allow the bills to come in. And therefore, to the extent that other courts have allowed them to come in, there's a split of authority. The reality is they're dividing the world into the wrong way. That
Different issues.
Right. Howell and Korenbaum and the cases that follow it are cases with a negotiated rate differential. In that situation, the bills don't have relevance. In lien cases, Pebley, Bermudez, Moore versus Mercer, Upanskaya, those cases, then the bills do have relevance because they represent the amount that the plaintiff incurred and is going to be required to pay.
So real quick, we're almost short on time.
Okay.
So really quick, I want to know, because you're still at the forefront of this issue. What is the current issue with medical bills that's happening right now, which is the next? So we've already put to bed no insurance. You treat on a lien. You're in a different marketplace, I call it. What's the next step that's being taken by the defense bar into the appellate courts?
Well, it hasn't really percolated up into the appellate courts yet, but what I think we're going to see is a lot of disputes about the scope of discovery. Often, most treaters who accept liens for cash flow sell the liens to a factoring company. Right. So you're going to see a lot of discovery against the factoring companies to see how they ultimately dispose of the liens once they're in their hands. And all of the cases, Bermudez, Pebley, Moore, those cases are grounded on the testimony of the plaintiff that I owe this amount regardless of the outcome of the case. And so the defense is going to test that to see how does it really work out in practice. And I think you're going to see a lot of discovery focused in that area.
So we could spend another 30 minutes on this, but we got to wrap up. But so if you're litigating cases and you're getting discovery on lien factoring, don't let it happen. try to nip that in the bud before they can actually dig into it.
Put the discovery in the round file under your desk.
Is that what your grunts do? They just T-file?
I say put this one in the round file.
All right. Well,
all right, well, Jeff, we could spend a long time with Jeff talking about this because he's literally at the forefront of this fight. He's on the front lines. But thanks, Jeff just popped in. We saw him, said come on the podcast, and he did. So thanks a lot, Jeff. Good sport and very informative, man. Thank you so much.
It's a pleasure to be
And no sleep till justice.
Welcome back to the Justice Team podcast spectacular. This is Tom Conroy, the alternative Tom at the firm. Tom Fair being the tequila to my mezcal. A little smokier,
nice.
little dirtier. All right. I'm here with two Justice Team members and a special guest. Let's start at the end of the row. Ryan, say hello.
Hello.
That's Ryan Conger, San Diego Justice Team member. Sevi, say hi.
Hello.
All right, that's Sevi Fisher, and we got Shane Gosdis with us. Shane, say hi.
Hey guys, how's it going?
Shane, tell us a little bit about yourself or die.
Oh man, intense. Shane Gosdis. I'm out of Salt Lake. Have a PI firm there, and been open for about 2 years. Before that, I did corporate litigation. So I was in pure hell a few years ago, and my life changed when I found PI.
Now, I imagine the corporate litigation practice is just a small, mellow type thing, right? Wasn't
Yeah,
big.
totally.
Yeah.
No big deal. Yeah.
Well, I imagine you're working for some big Death Star-like outfit, yeah?
Yep.
Yeah.
I worked for a couple of those, billable hours, the whole 9 yards.
Yeah, I got a little bit of that. Ryan's got a little bit of that.
Okay, so you guys have been there?
Yeah, we've been there to one degree or another. Different.
Here in Cali, or where were you guys at?
Here in California, Ryan was with a big firm. I was with a big insurance company.
Okay.
Sevi's a purebred.
I talked to him. He made he got lucky early on. It's gonna be criminal defense, and
Absolutely.
the stars aligned.
All right, Shane, so how's it been? You're 2 years into your project now. Why don't you tell us a little bit about what the experience has been like, some of the positives, some of the challenges you faced?
All right. It's been awesome. It's been the best thing I've ever done. So I was with another PI firm for 2 years before that, left, took a handful of cases with me, maybe like 10 cases and just started virtually with nothing. And it's been awesome. Like, I've just had a great time, got a lot of really good cases, slowly build up, learned a lot. I've been working with a guy out of California who used to work at Paris law firm, who's been helping me incorporate a lot of your guys' tactics. Because Cali is about 20, 30 years ahead of Utah in terms of strategy. Honestly, in terms of PI strategy and how you guys work cases and opening limits and stuff.
Similar to the Cold War in the 80s, sort of like, Uzbekistan is about 40 years behind.
It is, yeah. Like, the concept of opening policies doesn't exist in Utah. Like,
oh, wow.
People don't do that there.
Huh.
Except
Okay.
me. So.
How was the transition of...
Yeah, I was going to ask, what's the transition been like?
Having to screen your own cases versus just being handed a case by the firm and saying, good, bad, or indifferent, this case is yours?
It's wildly different because when I was working for a firm, cases are important. You want to do a good job, but when it's your case, your screen, it's going to be your money coming out of your account. That changes the calculus.
And when
a
you
lot.
sign it up, now you own it. Right?
You own it. You own the costs. Like, oh, I got to spend $600 to file this case. Like, that's nothing. But when you start filing a lot of those and you're new, that changes the calculus.
For other people who may want to make that similar sort of switch into their own practice, is there any sort of helpful tips that you may have as far as like funding your cases? Like, did you reach out to any sort of like loan companies, or did you just kind of?
I haven't worked with loan companies. My buddy's trying to get me hooked up with one of those. I've just been totally self-funded. The only thing I've done is, which I'm sure you guys do quite a bit of with smaller firms, is just if I have something big, sometimes I'll co-counsel with a bigger firm in town if I'm feeling the heat on costs.
Let me stay on that topic. What is there a pronounced culture, a sort of a coalition of sorts in Salt Lake or in Utah? Because here in California, there's a pretty big a boat that everybody rides together on, and
right.
rising tide raises all ships, that kind of thing.
Yep.
Similar in Utah?
Yeah, Utah's not near. So there's probably three big firms in town that are the guys on TV and the buses and radio. And then you have two firms in town that are actually litigating big cases. So you got the three kind of TV attorneys, two firms that are decent size that are litigating kind of big cases for us out there. Mm-hmm. And that's the universe in terms of big firms.
Are those litigation firms good about getting the smaller guys involved and partnering up on cases?
They just take them. I think if you refer a case to them, you're kind of like sending it to them and no longer involved type thing. Would
you be in your mind? Do you like that kind of setup, or do you prefer more collaboration?
Yeah, collaboration for me. Yeah.
Okay.
Yeah. So yeah, absolutely. I was just talking to Evan off air about. Mm-hmm. Working with you guys on a case, maybe bring you out to Utah for different.
Are you solo with your practice?
Solo. So me, two paralegals, office manager.
Smooth sailing, easy breezy.
Yeah, easy breezy. No, it's awesome though. Like costs are low. Got a really cool office location. Mm-hmm. Doing some innovative stuff for Utah, at least, kind of on the policy stuff and. Kind of working up concussion and post-concussive symptoms really early in the case.
There's probably not much that you miss about corporate law.
Oh my gosh!
But the collaboration, what about that piece?
No, I don't miss anything. I got really good litigation training, like I'm sure you guys did wherever you were at. Like I learned a lot, like kind of on all that stuff. But I would come home every night and tell my wife I couldn't be a lawyer anymore. Like I can't handle it. I have to do something else. Like, I'm going to die if this is what I'm doing the next 30 years. And then I got a job with a PI firm out of California, out of Park City office, and my whole world changed literally overnight. Like, what have I been doing? Like, why have I?
So it sounds like it's been a rocket ship, positive change for your life.
Absolutely positive.
So let me ask you this. What challenges or what things have you seen in your transition that have given you pause or maybe caused you to think, oh, boy, I don't know if I can really wrap my hands around this?
The challenge, and, all younger attorneys probably think about this in the PI world, like, dude, can I start my own shop? Like, I see what Bob's doing. I want to be Bob. Like, I'm going to start my own shop in Santa Monica. But, it's scary as hell, right? Like, money's up and down. Unless you have a huge bankroll, it's scary. You guys, how our business is. So that's the only obstacle in my mind. Once you can get over that hump of, just having some consistent cash flow and cases coming in, then you're good.
Sevi, there's a vacant corporate spot in Utah. What do you
Right.
think? Are you ready for a challenge,
Yes,
Sevi?
That'd be a great fit for Sevi.
That would get back out.
He's
I
been fired in a
I went to college in Salt Lake City, so
I know.
I'm familiar
Yeah.
with the area.
Yeah.
The Wasatch Mountains are beautiful.
Yeah,
Yes,
I'm
sir.
right down in Murray.
Sevi, how long would you last at a big firm?
At a big corporate firm doing corporate defense law, Sevi would be there. He'd leave
How long would I last
Over
before somebody threw me out?
Yeah.
Yeah, before lunch. Before lunch on the first day.
Corporate? No, he's coming to work with me, dude, not
Yeah.
corporate. Like,
Yeah.
your PI in
They'd go
Utah,
to take
dude.
his badge photo, and he wouldn't show up on the film.
Yeah.
just not cellular on a cellular level.
You
not
know,
made for
yeah,
it.
and we were talking about that earlier. The stars, aligned for me, and in working for the Simon Law Group right out of law school, because I wouldn't last anywhere else.
Right. Okay, tell me about working Simon Law Group. I'm in Utah. I follow you guys on Instagram. I've been out to Cali for a few events, and I met Bob last time. How is it working at the firm?
That's a great question because you've got a purebred, dyed-in-the-wool plaintiff's type lawyer. Ryan, I'm not going to speak for him. I think my perspective has different twists and turns. But let's go, Sevi. Let's start with you because I think you might have the most vigorous response here. How is it?
Yeah, I think it's fast. You could be, we could be all of a sudden one day, no trials on Monday. We could be popped into, 2 or 3 trials at any given time, which takes a lot of resources, as you probably know. You could be doing expert depositions for, 6 different cases on any given week at our firm, which just requires a lot. It requires a lot. But then, we, part of the beauty in what we do, as you sort of alluded to earlier, is leaving the sort of the corporate world is you have freedom. You know what I mean? Nobody's putting their finger on you, telling you, be here from 9 to 5 or be here from 8 to 10 or whatever. You kind of have your freedom and you get your work done and everybody wins.
What about Bob? Is he in the weeds and the details on your cases? Like, you need to do this, that.
Which one is Bob? I don't see a ton.
Not really. No.
Looks like he'd let you run your own show.
The greatest thing about him is he's accessible, but not micromanaging you on everything. So he's there if you need him, and he will sort of helicopter above and make sure everything's getting done. He'll just ask for an update once in a while, but for the most part, everybody's hands off, and that's the cool thing about our firm and the environment is we all kind of feel like our own boss. Which I think is great, and I think it's empowering, not just to myself, but everybody that sort of does their case.
It's the best way to get everybody's 100%. I think
Sure.
too. When
Ryan, you made a transition very similar to Shane's, I think. So why don't we ask
long
you?
ago? Yeah, tell us
how's
about
it been
yours.
for you?
I was a partner at a big firm. I was there, I think, for 7 or 8 years, and now I've been doing the plaintiff thing for about 5. I have my own shop here in San Diego, but I'm of counsel for the justice team, and it's phenomenal. I mean, there's so much collective experience and all different types of experience amongst the group and everybody is a little hyper probably. I mean, super go-getter mentality, I think, across the board.
Right.
So, you learn a lot. I mean, nobody's telling you what to do, but if you want to know what somebody thinks, they're not going to be afraid to tell you that either. So I think that's awesome.
We have a good environment where it attracts a lot of people. I mean, I think we get probably emails, probably a dozen emails or so a week, if not more, asking for jobs at our firm. And we've developed an environment where, it's work hard, play soft kind of deal. And
what?
Also just
Right, he's like,
and also
Sevi, I play hard,
and
friend.
Also the ability to learn in our firm is insane. I mean, you learn more, working for a firm like ours in 4 weeks than you will at a big defense firm in 5 years. You come over to our firm, it's like, you start. I think I remember my very first time, I get my bar results. And, Bob didn't even want me to wait and get sworn in with, like, the rest of my class. He's just like, oh, we've got a notary downstairs. Go get sworn in. You have a depo on Thursday. So that's our environment, and that's why
Into the deep end.
and that's why we have so many successful lawyers at our firm. Starting from second year lawyer, first and second year lawyers, all the way up to 10, 15 year lawyers, because of that sort of like, you're going to learn immediately. You're going to get thrown into the fire. You're going to do a trial within your first month of being a lawyer, and not a lot of lawyers will, partners at other firms will allow their lawyers
We just
to do
had
that.
two, I think they're first year lawyers, but
They
it
are.
was certainly their first trial. They tried it together. Blake and Nas, shout out to them. They had an uphill battle the whole way, and they got a great result. And that kind of thing, the two of them together,
Like a $285,000 verdict
Yeah,
on no
spectacular.
surgery case out in a very conservative jurisdiction.
That's
I think
awesome.
Blake's been practicing a year maybe, and Naz just, I think she got her bar results a few months ago.
Yeah.
Wow.
So it's that kind of,
Impressive.
where, and Bob's there, giving his advice and stuff, but for the most part, it's like, here, pack your cars and go try this case.
So Shane, let's come back to you for a sec, because you're in this space now where it sounds like it's been a great transition for you, very positive, and you're developing the firm. Do you have, and I think I know the answer to this because you've mentioned it, intentions for growth, plans for growth? Are you comfortable discussing your plans, or are these Soviet state secrets?
No. It's funny you asked. So,
I'm not going to tell you what I'm doing. Shut
right.
up, dude.
no, I'm actually in the process of partnering with an old-time PI attorney. There's a city called Ogden, north of
I know
Salt Lake.
Ogden.
Yeah, Ogden, Utah. So this guy's 75 years old. His paralegal's been trying to get me to meet with me forever. I'm like, why would I do that? It's weird. Finally met with him, and he's crushing it, and it all clicked. And so I'm merging with him, and he's got he's been in that city for 40 years and has a lot of referrals. And so
Are you going to branch into Provo, perhaps Moab?
Moab, yes. The Moab office is next. Have you been there?
Go down to St. George, perhaps?
St. George.
Yeah.
Hey, you know the
At Provo, you have to close your
Well,
office.
Utah, this is not debatable. I don't think. I think California might be second on my list, but Utah's got the best national parks.
Yeah,
in
no,
the
we do.
nation.
It's pretty cool.
Hands down.
Yeah.
So.
Maybe Provo, Utah County office.
Close your
Okay.
office at 3
Yeah.
p.m. every
All
day.
right.
Right. Yeah.
So you're happy you're happy with the level now,
Yeah.
but for you have a horizon you want to get up and over, and perhaps after that another horizon.
yeah,
So it's about
absolutely.
growth. Yeah.
Yep. Growth
Okay.
is on the horizon for sure.
Okay. Super.
Yeah.
That's good.
Tell me about. You didn't tell me your experience. Where'd you come from?
I tried to duck that question. I actually got disbarred 4 years ago. It's been kind of like a weekend at Bernie's thing.
Right.
I'm trying to stay afloat.
Right.
But now that's out there, and I'm taking the train.
He only works when the music plays.
Yeah, I'm taking the train home after this. No, Bob and I go way back. We were friends for a while ago. He was trying to get me on board, and you keep asking.
Were you doing PI the whole time?
I had for about 7, 8, 9 years, whatever it was. Did insurance defense.
Okay.
Catastrophic loss on the other side, literally on the other
Right.
side of the equation I'm on now.
Yep.
Great people over there, but at times the work was what it was.
Right.
And for me, I echo everything Sevi said about the nature of the firm, what Ryan said about the collaboration, the great minds that you get to work with.
Sure.
That spirit of esprit de corps, as the French would say.
Yep.
The fighting man's mentality. But I personally, and Ryan at times was sort of like my de facto guidance counselor. I personally struggle with culture sometimes. I tend to be a little bit more aloof, a little bit more. I don't put myself out there as much.
Right.
I'm not always on the front foot. And the culture of this particular shop and this particular arena we're in, not so much that I was questioning the decision, just the culture I had trouble getting used to. Kind of like going from East Berlin to West Berlin. Still the same city. The streets look the same. But different.
Because
He
why
uses
it
all
was-
these analogies
it
that
was-
I never understand.
What was
Maybe
the
you're just too smart for us.
He is way too smart for us.
No,
Go
it
from
was-
West Berlin to East Berlin, for those of you who've never been to Berlin.
No, I'm talking about Cold War stuff, going through Checkpoint Charlie. That's what I'm talking about. Yeah, Shane gets me. Shane, don't listen to these two idiots.
right? I got you, man. I got you.
Sammy, let's just go.
I get it.
No, for me,
When does the guy fall?
I'm more simple-minded. Like
You know what I am? Here's my
West San Diego versus East San Diego.
Here's my problem. I'm a dyed-in-the-wool New England cynic with that Irish Catholic mentality of you just sort of like, if there's a problem, you just deal with it, and you take the feelings that it causes and you stuff them down.
It's his way of saying he's a dick.
No, I'm just listen. I'm a little cold. I'm a little aloof. My wife is stunned by this revelation.
Right.
And in the plaintiff's world, especially this arena,
Right.
it's about collaboration and getting together,
Sure.
and putting your minds together, and go, and everyone's very bullish on things, and I'm this sort of grumpy cynic
Right.
going.
He doesn't like the group project.
Got it. Like,
No, listen. I love. I mean, here's the thing: the collaborative nature of things, the togetherness, the esprit de corps I talked about
Right.
a second ago. That's raised me. You know,
Awesome.
now, and I feel like my temperament is getting better.
you're about
by
to hit
it.
your stride.
Yeah, I think I have in one way or another, and I've had some pretty good results so far
Awesome.
here. So, you know, for me, the transition wasn't clean internally. It was
Right.
clean professionally. It was fine. I was able to do everything. You know,
Did you find yourself when you switched like undervaluing cases or poo-pooing cases because you'd been in that mindset so long?
I still do. I am.
You do, yeah. You're the cynic of the office.
I am. At times, they bring me cases,
It's
and
great,
Bob's
though.
like, go,
Yeah.
go, 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 go,
You
and I
need
say,
that.
Yeah.
Tom's
Yeah.
cynicism has helped us avoid some really
Really?
shitty cases. that and we've
Yeah.
now reached our cussing quota for
Yeah.
the.
Yeah.
All right, our executive director and producer, Teresa's giving me the wrap-up sign. She's tired of hearing us talk.
All right.
So let's sign off. But before we do, Shane, I need you to tell us about the Utah Law Pod real quick.
Yeah, hit me up, Utah Law Pod. You can find me on Facebook and Instagram, and they'll be on iTunes soon, but would love to have you. Thanks for having me, guys.
Awesome. Shane, it was cool having you here. You can find me personally, again, once more for my listeners at the Male Attorneys who have a passing resemblance to Ellen DeGeneres blog, and for Sevi and for Ryan. And Shane, we'll sign off. Thanks,
All right,
guys.
thanks,
Go
guys.
Utes.
All right, go Utes.
Legal issue that I wish you saw. Your Honor, Mr. Know-It-All. Clear your eyes and I'll show you, 'cause with this writ I'll share. With this writ I'll share your lousy view. Yeah. With this writ I'll share your lousy view. Publish me up some new case law. Young Appellate justice gonna make the call. Falling all over myself to argue perfect points in public policy, 'cause with this writ I'll share your lousy